Yeah, exactly. I'm sure you can appreciate it when I say, I just wish the politicians would leave the health sector to the health experts.
Yeah. Too much politics.
Can't deny that. Good morning, Mr. Holden.
Morning, Senator. Can you hear and hear us all right? And we'll check your audio.
It looks like it's still connecting to audio.
I
Oh,
think so.
is he calling in?
Who's AW?
No, that's not him.
Yeah.
Ah, there you go. Is your audio connected? Oh, he is muted.
Oh,
Great. Computer audio. It looks like we can hear and see you well, Senator. Can we get a quick sound check?
A, B, C, D, E, F, G,
Perfect. Thank you, sir.
A, G. I don't know my alphabets anymore.
You remember your alphabet. That's great.
Great. Thank you. And Julie, I just sent out the text. We're streaming live now. on
Thank
the-
you.
the-
I see, here comes Cynthia. Cynthia, you want to test your microphone so we know you're,
Can you hear me?
yes,
Perfect.
Good morning, everybody.
morning.
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 You know, we're doing them.
Since we only have a matter on consent, I'm going to leave you guys unmuted. I'm going to leave you unmuted. Although, Mr. Weiss, since you're not appearing, I'm going to mute you.
Before you mute me, just be prepared. I may need to appear.
If you need to appear, then we have to hold a hearing. Okay.
I understand.
Okay.
Not my desire, but going back over the recent emails, I think we may have to.
Okay. Well, we're all here, so I think that we can begin. Okay. Madam Clerk, are we ready?
We are ready.
Okay, thank you. Okay, good morning. The hearing board of the South Coast Air Quality Management District is in session. Today is May 12th, 2020. Time is 9:00 a.m. and we are meeting via remote hearing on Zoom. And that is because of the current COVID-19 pandemic and the stay-at-home orders and executive orders of the governor of the state of California. We have one matter that is currently on consent, although we've been advised it may be taken off. I don't believe any of the hearing board members have taken it off as of now. And that matter is Tesoro Refining and Marketing Company, case number 4982-124. And it is for a regular variance and alternative operating conditions. And I'm going to mark the papers that we have. We have, first of all, a joint stipulation of the parties. And since it looks like it is on Tesoro's, Mr. Weiss's letterhead, we're going to mark it as exhibit number 3, I believe. Is that correct, Madam Clerk? For petitioner? So we have to.
Yeah.
3. Okay, so we're going to mark the joint stipulation as exhibit number 3. We also have, let me go through the stipulation of the parties. Okay, the parties are agreeing to have the matter placed on consent. They agree that the declaration of Adrian Rosu shall be admitted into evidence. And so we're going to mark the declaration of Adrian Rosu as exhibit number 4. And that, just to make sure we have everything, that exhibit has 3 A, B, and C photographs that are attached to it. But we're just going to mark that all as exhibit number 4. Parties are agreeing that all the evidence that was submitted at the March 24th, 2020 interim variance petition and alternative operating conditions hearing will be incorporated into the proceeding. They are hereby incorporated. And the parties also further agree on proposed findings and decision and order granting the regular variance in AOC. And we're going to mark that proposed findings and decision as exhibit number 5. Further, the parties agree the petition will be amended to request 6 months rather than 1 year. The original petition asked for a year, but the request is 6 months, and when we get into discussion and deliberation, we'll note for the record that the variance in AOC would end then, or if they come into compliance before then, whichever comes first. District does not oppose the granting of the variance in the AOC. It is not expected to result in violation of Health and Safety Code 41-700. And the parties have agreed to the regular variance and the AOC conditions that are included in the proposed order. And with that, there are a number of, there's a phone number and a number of people that I don't recognize. And so at this point, I'm going to ask if any member of the public wishes to be heard before we move into deliberation. I'll just give it a second. Oh, sorry. And there's one other thing while I'm waiting, and I don't see anyone. I'm going to mark the board members. Just let me know if you did not receive it, but there is a email chain. The top one I have was from the clerk. Oh, maybe this is the wrong one. Well, it's dated May 8th. And what it is were questions that I had before removing the matter. I mean, before agreeing to leave the matter on consent, and responses from both parties. And so I'm going to mark that chain as Hearing Board Exhibit 1, so HB-1, so that we all have that in front of us.
Madam Chair,
Yes.
I think that include also, there was a question I had and responses from both the council and both district and the respondents council. I think that was also included.
I was going to raise that exact issue.
Madam Chair, I'm sorry. Yeah, Madam Chair,
Yes.
that email should have been also forwarded. It was dated Thursday, May 7th at 11:13 a.m. And
Thursday, May 7th.
yeah, the board members should have gotten that one as well.
I'm not seeing it, but let me see.
I have one that says May 12th.
Well, that's today's date.
No, that it's received on May 7th, but in the parentheses of the title of the subject, it has,
Yes, it has hearing on May 12th.
So that's the one you're talking about?
Yeah, it's dated May 7th. And
Right.
the first line says, here are the questions and responses to those questions asked
Yes.
by Vice Chair Balagopalan. Okay, so
Right.
that is the one regarding the questions asked by the Vice Chair.
Okay, great. Got it.
And then there was also questions asked by the chair. So you should have two emails, one dated May 7th, one dated May 8th.
Does everyone else have? I do not. I'm sorry, but I'm going back in my email. And I'm not seeing anything for this matter on May 7th.
There is.
Yeah, it was sent to you.
And then another,
11:13, I think. At least it shows I got it at 11:13.
That is correct. That is the time on May 7th.
I don't know why I did not see it at all in my inbox. Is it it's from the clerk of the board?
That is correct.
I don't see the May 8th one.
Is it possible, Madam Clerk, to just recirculate both of those? If not, everyone is seeing both.
Yes, I can have the clerk do that. If you want to hold on just a moment, I can get that done.
Yes, thank you. We'll go technically off the record while we do that.
Yeah, what I have for May 8th is the one for Weber Metals. Oh, maybe this is it. Maybe this is it.
Madam Chair, while we're off the record, may I ask a question?
Yes, although I don't want to get into a hearing matter unless we're going to make
Well,
sure both parties are
obviously
represented.
It relates to the hearing in some way, of course, otherwise I wouldn't be here.
Yes,
Obviously, we would like to keep this on the consent calendar, but the emails that are currently being looked for are very, very important to the matter. And I guess my quick question is, would the chair entertain providing some leeway for us to talk about those two emails without taking the matter off consent?
we can't do that. I can, either the matter is stipulated to and the parties are not appearing, or we're having a hearing. But we could have a limited hearing if you would like to.
I think maybe a limited hearing would then be my next approach, but let me see how the rest of this plays out, because if the board members aren't seeing those emails, I think that's a problem for everybody, frankly.
We will make sure that we all not only see them, but consider those emails.
Question, so the emails that are for two different dates, are we calling them both HB1?
No, we'll call, we'll wait until we're back on the record to mark them, and once we have them, but the ones that were answering my questions are HB1, but the other ones will mark differently.
Thank you for giving me that opportunity to raise that issue. I appreciate it.
Of course.
I think my hope was that in these exigent circumstances, we might have a little leeway, but I can appreciate that you want to be on the record.
Yeah, we have not suspended our rules. And again, you know, once we open it up for a hearing, oh, I think I got it. Hearing. Oh, is that what it is? Oh, it's part of, was it a response? Okay. Okay, board members, as soon as you receive any emails that you have not received, just go ahead and review them if you have not seen them before.
And Madam Chair, I take it once you've got them, then you're going to walk through them specifically about to be sure everybody has the same emails.
Yes.
Okay, they have been resent to all of the board members and to Mr. Weiss as well. Sorry.
I think now I see why I didn't realize. I think I've read this before, but because it was an add-on to the email chain, which presented us with the documents for consent. I didn't realize that that was the email. Okay, I was looking for a standalone. Okay, so does everyone have a copy of both email chains? If anyone doesn't, just let me know.
I do.
Okay, so we're back on the record. And so the email chain which had questions by the chair and responses from both parties. And I just want to make sure everybody has responses from both parties to that question. That chain is going to be marked as hearing board HB-1. Okay, and then from what I see, the email chain regarding Vice Chair Balagopalan's questions, there were two. And they're part of a chain which was conveying the consent calendar documents. And there are two responses with regard to why a report was not phoned in, that there actually was no non-compliance because the heater was shut down, and that the follow-up investigation was due to viewing the stack as being as leaning, is what I see. So I want to make sure everybody has those. They've considered, sorry, there's a barking dog in my background.
So that is HB-2.
-2. I apologize for my barking dog. It's a little late for her morning walk. My husband's taking her. Okay. Okay, board members. We can begin. Anyone wish to begin deliberation? I know, Mr. Weiss, you wanted, did you want to raise taking this off consent?
Well, I would, under your rules, I believe I have the opportunity to pull it off consent up until it is submitted. If that's the case, and I can listen in for some of the deliberation before making that decision, it might make everything easier on everybody.
Generally speaking, it would be before. So that's why I think if there's a particular issue, we can't stop the deliberations midstream if they're not going a particular way and have a hearing now then held. Either the hearing should be held or
I kind of want to have my cake and eat it too, if possible.
of course, everyone would like that. But since Ms. Roberts is here, but I don't know if she's prepared for a hearing, but if there's something you'd like deeper explanation and like to call a witness or just make opening or closing statements, we would open the hearing. But once we open the hearing, then if there's any questions, we might.
And that's exactly why I wanted to interrupt you before you went into deliberations, was to kind of have that conversation. Based on the email chain that's just been marked as HB-1 and the back and forth primarily between yourself and district council, though I did weigh in on the 8th as well. That goes to a fundamental issue as to whether or not the 6 findings can be made. And there's a clear discrepancy between the chair's statements and the district statements supported by petitioner. And so I unfortunately, I think I'm going to have to address that issue because of the statements that are in that email. And I just don't know how the board intends to resolve that. But if I can, what I would like to do, I guess at this point, and so the board knows, we have been in close contact with district council and talked about this issue. Obviously, we've gotten all of our ducks lined up to submit the papers on the consent calendar. But the board chair seems to feel that there has to be some testimony on the underlying clause. And I don't see the health and safety code findings as requiring that, and either does district council.
Okay, I didn't read my
I
response
may
as such, but
briefly
Okay.
respond just because I do believe that my email might have been characterized, Madam Chair, if that's permissible, if we are making opening
Why
statements.
don't we just go ahead and,
well, are we going to open up the hearing?
Well, Madam Chair, my concern is that if this hearing is being opened and if the petitioner is making an appearance, then district council would like to make an appearance on behalf of the executive officer to ensure that they are heard
Yes,
as well.
absolutely.
sounds like we're opening the hearing. Ms. Roberts, yes.
So I do want to speak generally to the email in response to the chair's question. I don't know that there is necessarily that big of a distinction, but I do believe that the chair's question goes to why the district perhaps at the interim variance hearing did ultimately, after hearing the evidence, take a position of opposition on the good cause phase of an interim variance hearing, but on the regular variance has not taken a position of opposition. And I believe the email goes to the distinction between those two. That is not necessarily an uncommon position for the district, and that does speak to both the hearing board's guidelines of a more stringent standard when we are taking something without public notice as an interim variance hearing. And that is a heightened standard. And the specific finding that is required looks to the circumstances underlying the violation. And it is that finding that was of concern specifically to the district on the interim variance hearing. It's not necessarily at issue in a regular variance hearing now that we have had the time for public notice. And as to a hearing, if the district is still prepared to take this matter submitted on the evidence that has been submitted and entered into exhibits 3 through 5, as well as the 2 hearing board submission emails. However, if the parties are, if the petitioner and the hearing board would like this, the district is prepared to present a witness should the hearing board have questions. Thank you.
And since we opened it, thank you. Thank you very much, Ms. Roberts. Mr. Weiss, first of all, let me just, since we opened it, I should just, on the record, who is appearing and representing Tesoro this morning?
Malcolm Weiss on behalf of petitioner.
Thank you. And who is representing the executive officer today?
Catherine Roberts on behalf of the executive officer.
Thank you. And Mr. Weiss, I don't know if you, since you simply were raising the issue that you were concerned about, whether you would like to make a more full opening statement.
Thank you. I actually would. And I'm wondering, Madam Chair, if as I am doing this, I don't know if you have the capability. I assume that you do, but if you could, I would like for you to be prepared to put up a couple of documents on the screen.
We can do a share screen, but you would have to do it and you would have to be granted permission to do so.
Okay. And I could probably do that. I have them handy if necessary.
And
We don't need to do it right this second, but maybe in a minute.
all right, just let me know if you need to do that and I can see if you have that capability. And if not, I know Paul Wright is on, and I believe others from the
I
IM
certainly
department.
have it. I don't know what you'll see if I if I click on it. I have 2 screens, so I'm not sure which one will pop up, but we'll see. Let me do one other thing then, just to be prepared. All right. So let me go ahead with the statement, and I do want to include excerpts from the rules and procedures of the hearing board and also the health and safety code that focus really, I think, directly on the questions that are raised by hearing board exhibit 1. So for my opening statement, we actually don't believe that there is a necessity to look at the incident investigation report or to know about the incident in order for the board to be able to make the findings under the health and safety code. We think additional evidence concerning the underlying cause of noncompliance could have been reasonable to consider in the context of the interim variance, but we think it's superfluous at the regular variance hearing, and I'll explain why in a minute. The question now before the board, though, is whether, due to conditions beyond reasonable control of the petitioner, requiring compliance would result in an arbitrary and unreasonable taking. That's straight out of the health and safety code. So a lot has occurred since the March 24th hearing, the interim variance hearing, and I concur with what Ms. Roberts said earlier about the distinctions between the findings that need to be made. But we have been working diligently to repair the heater, the SEMS and the SEMS infrastructure, and return everything to normal operations. We've been in close contact with district council, keeping them abreast of issues, working proactively so the district council was in agreement to submit the regular variance petition on the consent calendar. The board members understand this, but I think it bears repeating that certain things need to occur in order for a matter to be on the consent calendar. First, we needed to obtain the concurrence of district council in order for the matter to be placed on the consent calendar. And we also obtained district council determination that they would not oppose the granting of the variance, which you also just heard. We also provided the board additional relevant testimony and evidence in the form of a new declaration from Mr. Rosu dated May 1st. And we provided further evidence as to why compliance is beyond petitioner's reasonable control. Further, the petitioner and the respondent have agreed on the proposed findings. We've agreed on a stipulation. We've agreed on a proposed order. And we've agreed that the board is in a position to make all 6 findings required under the Health and Safety Code for the variance in the AOC and also for the AOC. The record makes clear that neither the district council nor the petitioner understands that information concerning the investigation of the incident impacts whether the board can now make the required findings. Otherwise, if either of us had felt that that was a necessary requirement in order for the board to grant this variance, we would have, to the extent possible, provided information on the incident. I would have to have been completely, deaf not to have heard how interested the board is in that issue. And that focus may have been appropriate during the interim variance. It's just not appropriate now. And that was the reason that certainly the reason I did not include anything about the underlying incident in the declaration or thought that it was necessary to put in the findings or decision. And the fact that it's not there and the district is still in concurrence that they won't oppose seems to indicate their position on that issue as well. What I would like to do, if I can, is bring up Health and Safety Code 42352A2. And I will share my screen and see what happens. Host has disabled participant screen sharing.
Okay, I don't know if, Paul, if you're there.
Still disabled. If you could do, it's just simply the health and safety code if you wanted to try it on your end.
I don't have it to pull up. However, I mean, I have it. I have it. I have it. I just don't have it to pull up. Want me to?
I think it's important enough for the board. Nah, that's not going to work. I think it's important enough for the board members to actually see the language.
Board members, do you all have a copy of the health and safety code section? We should have it. It is the 6 findings for a variance. We all have it and we can read it into the record.
Madam Chair, there's no way you can share screen?
I just don't have it up. And
Well,
I've not tried the share screen. I am no technical guru here.
Perhaps if you roll your mouse down to the bottom, something will pop
No, I
up.
know how to share screen. I just don't have it up on my screen.
Okay.
Um,
Is Mr. Wright trying to work on this?
I'm not hearing from Mr. Wright if he's there.
He's still there. His microphone's on mute.
I don't see him on the,
Okay.
usually he'll unmute. I see that the clerk got up to find him. Okay, let me see if I can. All right, I don't know what will happen if I try to pull this up on.
Okay.
Let me see. Let me
Yeah,
see.
he's on his way back, Madam Chair. He had to
Wait, I'm
step-
trying to do this.
Okay,
I don't know if I'll be successful or what it will look like.
Yeah, there you go. Perfect. You're getting there. If you can enlarge it a little bit.
Good luck to me. That's as big as I can make it, unless I can, let's see.
It's a little bit cut off, but I mean,
You want this one? Oh, it's cut off on the right, I see.
that's probably sufficient.
This is what you want,
That is what I want.
okay? If
But
I could highlight it, I would, but.
That's fine. You got it. And you don't even really need to do the whole thing because a lot of it's not really relevant to us since we're not a public agency.
Okay,
But the language is clear that due to, I'm just going to pull my hard copy up, that due to conditions beyond the reasonable control of the petitioner, requiring compliance would result in an arbitrary unreasonable taking or the practical closing and elimination of a lawful business. That phrase, requiring compliance, can be contrasted, now really test your technical skills, with the rules and procedures from the hearing board.
I'm having a hard time. I don't know why it's like.
You're doing fine.
Okay.
That's it. Yep.
Yeah, I know where to find it. I just, it'll take a little while.
So if you could scroll down to Appendix 1, the pages I don't believe are numbered, but it's obviously way towards the back, not that far back.
Yes, I know.
At the bottom of the second page, top of the third page.
Wait, you're not talking about this?
I'm not talking about that. That
Okay,
relates
you're talking
to
about
a little
this,
further down.
where it
correct.
says that it is,
I think that's it.
it's here, no.
Yes, that's it. If you could enlarge that. I really appreciate everybody.
You're talking about under diligence and filing?
Correct. And if you can enlarge the bottom of that page and the top of the next page, that would be useful.
Yeah.
So as you're doing that, so our understanding is that based on the Health and Safety Code 42352A2 that we just looked at, really contains a very different standard than what was required for the interim variance. And we know that this is the case because your hearing board rules say so.
Can you please, I know what you're
You're fine. You're
generally referring to, but can you please point it out?
fine. I will, but you're good right there. No, go back up a little bit. Other way. A little bit more, perfect. So perfect. So I'll point out where I am here. So here, what it says, it's the second to the last line on that page. And it begins with, and this obviously is focused on the interim variance, and I'm trying to demonstrate the difference between the requirements for the interim variance and the regular variance. And here, the language of the board's rules and procedures says the board's inquiry in these circumstances is more limited in scope than the taking of property or closing business finding of 42352A2, which we just looked at. And because 42352 addresses the impacts of granting or denying the variance, whereas the good cause finding only addresses the impacts of delaying the hearing, presumably for a matter of days or weeks. So that's how we know that the findings that need to be made for an interim variance really are quite different than the findings that need.
I think you're looking, if you give me a moment, I know what you're looking for, that's not it. Because what you're reading out into the rule, reading out into the record, this has to do with the denial of the variance will result. This is the harm. And what they're talking about here is that the primary focus of the good cause hearing is between the time of the good cause hearing and when this could be heard. So it's a short, limited amount of time. But when you're looking at the full harm, we're looking in this case for 6 months worth. That's why they're saying it's more limited, but you're looking at a different finding. What you're looking at is what you're looking for. I think it's under emergency. Just give me a moment. Here, it's the could not reasonably have been anticipated or avoided or anticipated in sufficient time. And this is what you mean. The language is intended to be stricter than the beyond reasonable control finding of the petitioner. Is that what you're looking for, Mr. Weiss?
I think that supports what I was looking at before, but no, I actually think that the portion I was looking at is also relevant, only for the purpose of highlighting that there is a distinction between the findings for the good cause portion of a variance on an interim and what needs to be found under a regular variance and the 6 findings. I think they're both relevant.
But I want to be very clear. The other one I don't believe to be relevant for the reasons you're stating. This I do, and I was going to raise this for all board members to consider when we are in deliberation.
Okay.
This is, board members, when we are looking at the findings we need to make for whether we have good cause to proceed in absence of notice to the public, we're looking at different findings, as we know, from the 6 findings for a variance. And one of the findings, which was the problematic finding during the interim variance hearing for this matter, was that the violation could not reasonably have been anticipated or avoided by petitioner. And that was because we found we didn't have enough evidence at that time of root cause, and that was a concern to members of the board. So to point out here, and I think this is going towards Mr. Weiss, what you're looking to bring out for this board is, while we're looking at the 6 findings, we want to take into account that the language for the standard for interim variance finding is stricter. So that's what it's saying. This language is intended to be stricter than the beyond reasonable control of petitioner, which is what we're looking at today, now that we're looking at as a regularly noticed hearing for a regular variance. So the other one, just so we're clear on the record, that you were looking at, that has to do, it's a temporal limitation. It's looking at, when we're looking at a denial of the variance will result in, the harm we're looking at is simply, the primary focus is the period of time between the good cause hearing on the emergency or interim and the earliest feasible date for a noticed hearing. So usually for this kind of a hearing, I don't know how long, I don't recall how long ago, usually it's about 45 days. We're looking only at that period of time, whereas when you're looking at the taking of property or closing a business for today's hearing, now it's a different, it's also different in that it's a longer period of time at which there could be fines or harm or losses of income for a petitioner. So just so we're clear on the record, they are different, and those are the ways they are different.
And Madam Chair, I appreciate that explanation. My only point in raising the highlighted portion that you have highlighted right now is simply to drive home the point that there are different findings to be made, and your rules and procedures make that clear, as you just did as well.
Thank you very much. I think that's important to point out.
So let me go ahead and finish up if I may.
I'm going to stop the share. Is that okay? Or do you want to leave it up?
Yeah, you can pull it down.
Okay.
That's fine. I think we've made the point. And the reason I felt like I need to go into that was due to the emails back and forth that were, as I indicated, were identified as Hearing Board Exhibit 1. So looking back at 42352A2, the Health and Safety Code requirements, it really is clear that we've got a different standard, and that what we're looking at for beyond reasonable control focuses on requiring compliance. So that, again, it reads that due to conditions beyond the reasonable control of the petitioner, requiring compliance would result in a taking or a closing effectively. So in our situation that's before you today, it's not only beyond our reasonable control to comply, it is impossible effectively for us to comply at this point. Without reiterating everything, I think it's clear with the heater not operational, with the stack removed, with the SEMS removed, with the SEMS infrastructure removed, with an order from the fire department, there just is no way for us to comply. And so not granting the variance would create harm to the petitioner, and it is beyond our reasonable control. It's just that simple. As District Counsel stated last Friday in her May 8th email, the evidence clearly demonstrates this includes, and the evidence includes the declaration of Mr. Hudgens and the declaration of Adrian Rousseau, sorry. Those declarations attest to the facility, that the facility was requested by the fire department to dismantle the stack associated with the heater, and that this dismantling necessarily required removal of the SEMS probe. The stack dismantling was directed by Public Safety Authority, and compliance isn't only beyond our reasonable control, but it's effectively impossible at this point. So if the board still is of the belief that, as stated in, or at least any member of the board is still of the belief that, as stated, there must be evidence on concerning the cause of the incident in order to grant the finding, in order to grant the variance and to meet the finding of beyond reasonable control, then I guess we could, for a very limited purpose, put on a witness who can address some of those issues. If the board believes that the district council and the petitioner are mistaken, and that it is required for the board to feel comfortable to issue the variance after making some significant strides trying to figure out whether or not we could present such evidence, or what level we could present such evidence. But in order to address the concerns of the board, we would be prepared to put on a witness that could talk about that at a very limited level. I don't think it's necessary. I think it's superfluous. I think it will extend the hearing in a way that is unnecessary. But if the board feels that that's just what it needs, then we'll go ahead and we'll do it. So we don't think the cause of the incident is relevant to determining whether to grant the regular variance. We've paid attention to your concerns and the questions you've asked. We simply don't see how that evidence is necessary to support the finding of beyond reasonable control. And I still believe, and I'll let Ms. Roberts speak for herself, because when I do, she seems to want to make clear that she's speaking for herself, and that's fine. But I think the district council and we are still aligned that the district's not opposed to this variance, that we think it should be granted. Obviously, it can't stay on the consent calendar now because it's been taken off, but we're prepared to move forward with a very limited testimony of one witness if the board feels that that is really necessary at this time in order to grant the variance.
Thank you. Ms. Roberts, did you want to add to your opening for it?
If I could just briefly address, I would like to not go over the differences between the regular and the interim findings. I think that has been made clear between Mr. Weiss and Chair's colloquy going back and forth. I would like to clarify that the district doesn't necessarily agree that it's irrelevant as to what happened at the interim variance. And in fact, included in the stipulation was an incorporation of all testimony and evidence that was heard at the interim variance hearing on the premise that it is, in fact, there is relevance there. So I don't think we would go that far to say that it is irrelevant. The district's non-opposition at this point comes down to there's evidence that we believe, depending on how the board weighs the credibility and the sufficiency of that evidence, it could be sufficient to make the requisite findings. And that's the premise for the district's non-opposition in this point. As far as testimony, the district does have available Inspector Alteramsi, who, if the board has questions, particularly going to Mr. Balagopalan, I know had a couple of questions that related to the inspector's interactions at the facility. He is available to answer questions if the board would like. Thank you.
Thank you. Board members, let me just begin by saying that my question was prompted by my refreshing my recollection as to what our decision was on the interim variance by reading the findings in the minute order. And in the minute order, I had recollected that there had been a statement at the last hearing that there would be a root cause analysis that would be completed by April 6th. And so having not seen that in the papers, that prompted me, given what our decision had been, that we did not feel there was sufficient evidence that had been presented to make the findings for good cause. Again, keeping in mind that good cause finding is more stringent. And it was that the circumstances could not reasonably have been avoided. We didn't have enough sufficient evidence. We had decided as a hearing board and that we were looking forward to the root cause analysis. We didn't receive it. So that is why I wrote my questions. But in response, the response is that root cause analysis has not yet been completed and that an extension was given. And so we still have the same, again, we still have the same testimony evidence we received. We have received evidence about maintenance and work that had been done on the heater, inspections, etc. That there had been significant training of those who man the consoles for the heater, etc. those kinds of things we had accepted as evidence. Those kinds of pieces of evidence we shall, because it has been incorporated, we can weigh as evidence today. We also have all the additional evidence, which we did receive, but we received more of with regard to the fire department requiring the staff to be taken down, etc. All of these are evidence that all of these things are pieces of evidence that we will weigh, and as Ms. Roberts said, just give weight to whatever it is we want. We won't have more information, I don't believe, as far as when hearing board 1 was back and forth, there was no more information regarding the root cause at this time. But is it anyone's pleasure to bring on a witness and ask additional questions? I'll leave that open at this time.
Madam Chair, can I add? I think there was also, the district had given them an extension until May 29.
That's right.
To,
Yeah, that's what I was mentioning.
for the root cause analysis. So they had extended the time period to do that root cause analysis, knowing that it would take some time to do that. So that the other reason why it's not available. And as far as my question, I think it was answered both by the district council and the inspector that there was no breakdown report. And I think Mr. Weiss also response was Mr. Rosu has refreshed his memory and indicated that they did not call in a breakdown on that day. And that was my confusion the first hearing, that Mr. Rosu had called in a breakdown, but the inspector seemed to indicate that he did not get any notification of that. Turns out it was his response was due to an anonymous complaint, so that's why he responded. So my questions were answered as far as having the inspector on. So I don't need that testimony from the inspector.
Thank you. And I'm assuming that other board members probably don't have questions or would have raised them, but I see Ms. Verdugo Peralta. Did you, there we go. Go ahead.
Okay, thank you, Madam Chair. I think that was one of my main concerns, was why wasn't that report made? Because that to me is very serious, and which led to the ultimate breakdown, and the fact that we don't have the root cause analysis yet to go into that, that's where I'm having problems.
Okay.
Solving
Is there additional evidence, though, that you could elicit from this hearing today, knowing that the root cause analysis, that an extension was given by the district until the end of this month?
That's correct. And that's correct. And that's where, it's not that I'm not saying that there isn't good cause. I'm just saying, in my mind, it's just.
Well, I guess the question right now is, would you like to hear from any witnesses? I'm not sure.
Well, I don't think
here.
I don't think there's anybody who can give any evidence yet, because that root cause analysis has not been completed and turned in and given us time to go over. So therefore, we obviously have to wait.
I feel like I'm one of my son's teachers. Mr. Weiss is raising his hand.
I figured that'd be better than trying to verbally interrupt. Maybe I didn't make myself clear enough. If the board feels that getting some information on the incident investigation, to a limited extent, we have a witness available who could provide some information on that, even though the report isn't final. They have preliminary understanding of what went on, understanding that the report could change before it is issued as final. We could provide probably, my direct on it would probably be, certainly less than half an hour, maybe 10 minutes. If that issue is still leaving the board uncomfortable, then we can do that. But
I think that would be wise.
Yes, I agree.
Okay.
So should I swear in? Is that witness present?
He is present. Dennis, if you could unmute your microphone and put on your video.
Is that Mr. Kurt?
It is.
Okay. Where's, okay,
Can you hear me?
yes. Mr.
Okay.
Kurt, can you raise your right hand? Do you
Yes.
promise to tell the truth, the whole truth, nothing but the truth, so help you God?
I do.
Okay, thank you. Mr. Weiss, you may take your witness.
Mr. Kurt, can you please state your name and spell it slowly for the record?
Yeah, my name is Dennis Kurt, Denis Kurt.
And have you been administered the oath today?
Yes, I have.
Can you share with the board members what your role is with Tesoro?
Yeah, I am the Environmental Safety and Security Manager for the Los Angeles refinery.
And what are your job responsibilities?
So I have a number of groups, safety, process safety, industrial hygiene, security, and environmental. And they manage all aspects of those disciplines for both performance and conformance with rules.
And you've been, I can tell that you've been listening on the hearing today. Have you been involved in the investigation of the overpressure event that precipitated the filing of the interim and the regular variance and AOC?
Yes, I have. I've met with both representatives of the fire department and the Department of Industrial Relations, or OSHA, when they initiated the investigation. I've provided them people to work with, and when they have data requests or need information, I approve all of that before it's given to them.
So have the, we understand that Tesoro obviously has not completed its final investigation, written the final report, which is now due in a couple of weeks to the district. Can you explain the role a little bit of the fire department and Cal OSHA in particular? Have they completed their investigations that they're required to do?
Neither of those entities have completed their investigation. OSHA in particular made another data request last week on Monday, I think it was, for more information. And so they're still collecting information to do the investigation. And the fire department is still working on theirs as well.
And do they have a time frame within which they need to finish their investigations?
They need to finish it in early June, yes. Beginning of June.
So you've kind of outlined generic issues about what's going on with the investigation and your role. Do you have authority to talk about the investigation at this point from the company, at least in a very limited capacity?
Yeah, so we're at the end of the investigation. We're nearly complete. I did request permission from my superiors to discuss the investigation and what we've discovered. And I got that approval just recently, I think yesterday.
And that would be to discuss your preliminary findings with the understanding again that these findings may change because it's not a final written report yet, correct?
That's correct, yes.
So what's the first preliminary finding of the investigation into the overpressure event?
So the initial event was the failure of what we call a flow pass flow instrument. This is an instrument that detects the flow through one of the coils in the heater. And it malfunctioned, and when it malfunctioned, it gave a low reading, and a low reading caused the heater to trip.
Okay, so let me see if we can talk about that just in a little bit more detail. So you're talking about the flow through tubes. Can you explain that in a little bit more detail? What is actually flowing through the tube?
Yeah, so this particular heater has a product flowing through the coils. It's hydrocarbon material. And then there's a burner that transmits heat from the burner into the coils to heat up the fluid, the product. If there's no flow in the coils, the risk is that the temperature could get too high. And if the temperature gets too high, you could have a catastrophic failure of those tubes. So the instrument detects the flow through those coils and will shut the fuel gas or the burners off to this heater when it detects a low flow.
So I kind of think about that. This may not be a good analogy, but let me lay it out there and see if this makes sense. Having grown up in Minnesota a little bit, I noticed that when water is moving in a river, it tends not to freeze as quickly because it's dissipating, because it's not able to freeze because of the movement. I think what you're describing is somewhat similar, that if the product in the tubes isn't moving, it can generate too much heat and cause a catastrophic failure.
That's exactly right. Without flow in the tubes to carry the heat away, the temperature in the tube metal temperature will get too high, and it could cause a failure of that tube.
And so what the investigation has determined is that one of the flow meters malfunctioned and gave a reading indicating that there was not sufficient progress of material through the tube, correct?
Yeah, that's correct.
Okay. Can you just, so if this meter was, since this meter malfunctioned, I assume that in the investigation, you would have gone back and kind of looked at the history of this meter and maybe when it was last inspected. Can you tell us when it was last inspected and what kind of inspection is done on these pieces of equipment?
Yeah, so this particular flow meter is a critical flow meter. We call it a IPF for a instrument protection function. And so these sorts of instruments are tested at a frequency. In this case, it's at least once every 4 years. The last test of this equipment or this flow meter was back in early November of last year. So it was just recently.
So that would have been early November, would have been 4 or 5 months prior to the incident.
That's correct.
When these instruments are typically good once inspected for 4 years.
That's correct. And they read continuously. And so they're continuously monitored by the operators, but we do check their functionality more thoroughly at least once every 4 years. Yeah.
And did the flow meter malfunction result in any non-compliance with district rules or permit conditions?
No, there was no district or environmental rules violated as a result of that failure. And so there was no breakdown called.
So there was no breakdown needed to be called in, is that correct?
Yeah, we couldn't call a breakdown because there was no violation at that time.
So I understand that you must have procedures in place so that if this kind of incident occurs, you can address it. But what I'm hearing you say is that but for this initial equipment malfunction, there would not have been any further action for the operator to take one way or the other. Whether the operator did this or did that, that never would have occurred. Nothing like this would have occurred if that meter had not malfunctioned. Is that accurate? Was that a complicated question?
Yeah, so if it hadn't been for this meter failing, there wouldn't have been the subsequent failure of the heater when they went to restart it.
So what I'm hearing you say is that but for this failure of this flow meter, the subsequent events wouldn't have occurred in the fashion they did because everything would have been continuing to operate
Right.
in normal fashion.
That's correct. Yeah, right.
I have no further questions.
Let me first, Ms. Roberts. Ms. Roberts, do you have any questions?
Yes, a couple of brief questions, if I may. Mr. Kurt, you discussed the timing of the investigation report as due to the district is now at May 29th. Is that correct?
That's correct.
And that is an extension from the original date that was noted on the notice to comply. Did the facility request that extension?
I believe that's correct, yes.
Okay, and you talked about how you're investigating as well as other public authorities, including, I believe you mentioned both the fire department and Cal OSHA. I just want to clarify, is your investigation dependent upon those public entities' investigation?
No, we are moving forward at our on our own. We will finish our investigation. We will present that to both the fire department and Cal OSHA, and they will finish their investigation after they get ours.
Okay. And you discussed some of your preliminary findings as you determined them prior to this morning's hearing and your testimony today. Have you shared those preliminary findings with the district?
No, not yet.
So the district has been unable to review or verify any of that testimony. Would you agree with that?
That's probably correct, yeah.
Okay. And in terms of, you noted that some of the instrumentation and equipment was failing, and that was kind of the subject of Mr. Rosu's testimony at the interim variance hearing. Was we couldn't decide or rule out either equipment error or operator error. Based on your preliminary assessment, have you been able to rule out operator error?
So the initiating event was the failure of that instrument. So that's kind of a mechanical failure. That was the initiating event.
So is that a ruling? Were there any subsequent events where there was? That sounds like it should have been either a yes or a no. I'm sorry.
Okay. Well, so after the failure of the instrument, the operator that was in charge of that heater attempted to restart the heater. This operator was well trained on heater operation, and he did not use the procedure that he was supposed to use. And because he did not use that procedure, he made mistakes that led to the overpressure event.
Thank you. And then just one last clarifying question. You said that you determined that as a result of the breakdown, the facility did not call in a breakdown on the basis of concluding that there wasn't any violation. Was that a conclusion you reached, or that was some concurrence provided by the district?
That was based on my environmental department's interpretation of the rules and the fact that we did not violate a rule at the time.
Thank you. I believe that's all my questions.
Okay.
A couple of follow-ups, if
Thank
I
you.
may.
Okay, why don't we do that, and then
It'd
Mr.
be
Dugal.
very, very quick. Mr. Kurt, once the company has completed its independent investigation, what happens with that document?
Yeah, so per the CalARP regulations, that report is posted on the CUPA's or the fire department's website. It's a public document at that point. It'll also be presented to OSHA. That probably makes it a public document as well. And so it'll be out there for everybody to see. And that's why we're very careful to make sure that it's correct and it has all the right information in it.
And just to be clear, you left out one other important agency who will get the document.
Oh, I'm sorry. Yes, I mean it'll be available to the AQMD and given to the AQMD as well. Absolutely.
Which is also part of the notice to comply, and it's
Yep.
I believe the
Yep.
only,
Sorry. Yep.
Is it? Am I correct that that is the only outstanding item in the notice to comply? Are you talking about that? If you're not, that's
I'm not aware of that. I'm not aware of that. No.
okay. That's fine. No further questions.
Okay, Ms. Verdugo Peralta. Yep.
Getting back to the root cause analysis report, which is scheduled to be given to the AQMD on May 29th. yet you're not going to have the report and information from Cal OSHA or the fire department in conducting root cause analysis reports for a utility. It has always been my experience that Cal OSHA's report, as well as the fire department's report, is extremely important for being able to have all of the information to complete the root cause analysis report. And yet they're not going to be giving you that until early June, you said, and you're going to be giving us, or AQMD, the report May 29th. To me, that's incomplete without the information from Cal OSHA or the fire department.
Yeah, I don't make the regulations. You know, we are required to give our report to them first, and then they have a longer duration to finish their report. So they will use the information that we provide to them, and then whatever other information that they've come up with to do their report.
And so will there be another report after you get that information from them back to AQMD?
So
It
our report will be our report. There will be, if the fire department and OSHA puts out a separate report, we can provide that to you, or they can as well after they've completed it.
And I understand, if I may, I understand that you're looking at this from a utility perspective, and you predicated your question on that. I don't know those procedures. Obviously you do, and I don't, but what is clear from the testimony is the timing of when the petitioner's report will be made public. You know, again, this is all somewhat conjecture because it's not final and it hasn't been published yet, but we anticipate that it will be, and we anticipate what Mr. Kurt is testifying to is accurate.
I'm just looking at
I
it
don't know
from
how
the
to
perspective.
organize.
Yeah, so one thing I can tell you is that we work very collaboratively with both the fire department and OSHA. They give us numerous data requests. They do interviews of the affected employees. They collect drawings, they collect procedures, they collect standards. Anything that they want, we provide to them. And so we're kind of running these investigations sort of in parallel. In my experience, they're very similar when they're all done. Ours is very much about what happened and how we're going to go correct it. Theirs are perhaps a little bit more about the regulations and where they think we may have deviated from a standard or a regulation if they find that. But
I'm very familiar with how Cal OSHA operates and what information they require and how their reports come out. My concern is that ultimately there's not a complete picture that's going to be given to AQMD because your root cause analysis is going to come before their final reports. And I would think, and it's again been my experience, and it has nothing to do whether it's a utility or not, it's the gathering of information. And therefore, once you have your information, then you can draw your conclusion for the root cause analysis. And you're going to be missing two important components to get to that point.
all I could tell you is they set the deadline of when they want our report, and then they are typically given 6 months to do their report. They give us usually less than 6 months. That's just how it's always been in the refining business. I don't know what to say.
And so again, then my question becomes, will AQMD get a final report that includes the findings from OSHA and the fire department?
I don't see why not. Those will be public documents.
I'm sorry, I need to try to get some clarification. Ms. Peralta, if you're saying, will a report that is due prior to two other reports is going to have the information of those two other reports in it, I don't know how we can answer that. All we can tell you is that we are responding to the requirements. If the district wants us to delay submitting our report further, we could probably do that, but I don't think that's what anybody's looking for. If this is the process, this is the process.
My concern again is that not all of the information will be in that preliminary, and I'm calling it preliminary, root cause analysis report, which is due on May 29th. That's
So, but is the question, I think it's a fair question, is the question, are you asking the witness whether that report, which is due before the other two reports, will have their findings in it? Or are you saying once those further findings are made, will that then be submitted at a later date to the district?
well,
What
that's
question are you asking?
that it's, I'm asking, the point is that how can your root cause analysis be complete without the information from those other two agencies? And how is the district going to know what the outcome is from Cal OSHA and the fire department unless there's going to be another report submitted to the district?
Yeah, I think what the witness testified to was that they're going to make their report public and that Cal OSHA and the fire department will also make their reports public. So the
Yeah.
district or anybody else will have all the information in those three reports. The timing, I understand your concern about the timing that doesn't line up the way we might appreciate, but we can't do anything about that unless we request another extension to submit the report to the AQMD. And we're not intending to do that at this time.
And
it just doesn't line up is my concern.
I get that. And that is to me a huge concern, because how can you have a conclusion of what the root cause analysis was without those two important reports? And I'm asking, and then I guess my question is also to Ms. Roberts, are you satisfied with the just receiving that report on the 29th without those other two components?
So to respond to your question, again, I am not testifying, just to clarify, but I do have an inspector who could testify and can sort of clarify. But generally speaking, the process that we receive from a facility is a summation of the facts that should be known to the facility after a full investigation. And while I don't speak for the fire department or OSHA, what AQMD takes from that is we make a conclusion as to whether or not any rules or regulations were violated, and we can come to a conclusion, but we do not consider the report that is submitted by the facility to be the conclusion of the matter, but it's rather a summation of the facts to enable our agency to conclude out an investigation. But that is a linear process.
Okay, I'm more comfortable with that explanation, that there will be ultimately, that AQMD will get all of the information and ultimately be able to, I guess, have a conclusion on the part of the district so that we know exactly what has occurred and what evidently has been done up to that point, correct?
Yes, I would agree with that. And again, I can have a witness testify, but at this time, the district has not reached any conclusion as to whether there has been a violation of any district rule or regulation resulting from this event.
And do you have that opportunity to do so once you receive the reports from Cal OSHA and the fire department, or is it done on May 29th?
It will be a combination, and most likely it will be depending on the information we receive from the facility. We have the ability to work in consultation with the fire department and Cal OSHA if we believe there is more information that we need to make that assessment.
Okay. I'm comfortable with that. Thank you.
Okay, thank you. Board members, anyone else before we let Mr. Kurt go? Any other questions for Mr. Kurt? Mr. Balagopan?
Madam Chair, I do have a question for Mr. Kurt.
Yes.
Mr. Kurt, I think your testimony was that there was both the instrument failure and operator error that led to the overpressure event. Am I correct?
Yeah, subsequent to the instrument failure, the operator did not use his training and procedures to restart the heater.
Can you briefly describe what the overpressure event was?
Sure. So in heaters, you need to combust fuel and oxygen, the oxygen and air. In this particular case, the console operator starved the heater of oxygen, and he ended up with a rich fuel system or a fuel composition inside the heater box. He incorrectly finally noticed that, and he made the wrong move by taking burners out. When he did that, there was an inrush of air, and if you have a hot heater box full of combustible material, and then you give it some air, it will combust rapidly, and that's what happened. That's what caused the overpressure event.
So consequently, was there an explosion or a fire?
There was an explosion inside the box. I guess you could call it a fire, but once the fuel was combusted, there's no more fire. So it's just sort of an instantaneous pressure wave due to that sudden combustion of the fuel gas that was in the firebox that caused the heater to split open.
And is that pressure wave that caused the stack to tilt?
Yeah, so this particular heater, the stack and the convection section is supported by the radiant section. And when the radiant section split open, then the stack and the convection section that was on top was not supported properly, and it was actually leaning over towards other process equipment.
And even when all that occurred, you didn't see the necessity to call in a breakdown because now the heater is not functioning, and you had
We don't
shut down.
That's true, but that does not violate any air district rules just because we shut a heater down.
Okay. All right. Thank you.
Okay.
Board members, any other questions for Mr. Curran? Senator?
It does not violate any district rules. That's what you just said. The rules say that SIMs should be in operation at all times. If it's not, that's a violation of the rules. Or do you understand that to be the case?
That's true, but we did not take, the SIMs didn't go out of service until later when we had to remove the stack. So that was beyond the time frame, I believe, of when we can call in a breakdown.
Well, they were not moving, they were not operating properly.
Senator, hold on. Senator, the testimony was that there was no necessity to call in a breakdown for the heater.
You call it what you want. It's a breakdown. It failed.
Yeah, but we need to follow district.
Oh, wait a minute. It failed. Period.
One at a time.
Accept the facts. Don't try to cloud the issue, because that bothers me. Please don't do that. Breakdown, it failed. And when you fail,
When you say it, what are you talking about? The heater or the SIMs? Can we just be a little more clear?
the heater is meltdown. Okay, overheated, meltdown, increased the pressure. So therefore, there was a failure occurred because the SIMs are no longer operating efficiently. I mean, I don't. You make it very difficult for yourself right now.
Okay. My recollection is the SIMs was still functioning even after the heater shut down. It wasn't until later when we had to dismantle the stack and bring the stack down, which is where the SIMs takeoff is, that we lost the indication on the SIMs.
Were you getting accurate reading? Were you getting an accurate reading, yes or no?
Well, it was reading air, so it would have been accurate for air, yes.
The results are not conclusively accurate.
Well, I think when the heater is out of service, if it hadn't failed, if it was just out of service, all it would be reading would be air in the stack, and that's kind of the situation we were in. The heater was down, the heater was out of service. It was still reading, but it wasn't obviously not in service, so it wasn't reading any emissions. But because the stack was leaning, we had to get the stack down. Once we took the stack down, we had to disconnect the SIMs, and that's when it stopped reading anything from the stack.
What you should really do is just tell us exactly what happened, be truthful about it. and don't fudge your statement as I interpret it right now. And then I can deal with that.
I guess what is it? I guess I don't understand.
You're saying that there's no rules were violated. If it's not operating properly, you violate the rule.
No, Mr. Senator, if I might, there was a violation of the rules as relates to the SEMS after 96 hours. And that's why we filed the interim variance almost, on the first available day that the district was open to file it. The heater itself, yes, the heater had a problem, but it didn't, and you could even call it a breakdown, but it's not a breakdown under the rules of the district that required a breakdown report to be filed.
Filed for petition after you determined after 90 plus hours that he had no confidence in the operation of the system. You had no confidence, and evidence showed it was not operating properly or efficiently or as designed. And so therefore you took more corrective action by filing for a petition.
Actually, the heater wasn't operational pretty quickly after the event.
It was operational?
It was not operational.
Right, well, then what does that mean? If it's not
It
operational?
was shut down. They because of the event, they had to cut off the fuel supply to the heater.
Let me ask, this is the first time this happened over at that location. It's 6% of your business. Question.
I don't know the answer to that. I don't know if you do.
You don't know whether or not it's ever happened before.
That we've failed this heater before? I'm not aware that we've ever failed this heater before.
A similar failure at that facility. You got more than one heater operation functioning at that facility.
Well, not every heater would cause the extent of damage that we saw. I mean, this was significant damage. I personally have never seen a heater damaged this severely in my 37 years at this facility.
And now the reason why I didn't vote for it initially, because evidence was not clear to me that you didn't do what you should have done or could have done. I suspected then and now, as you explained, it's a human error. Okay, and he's well trained, and he made these. Now you're saying here's the mistakes that were made. My hope after the interim variance that by the time you request a regular variance, all that information was made available to us. But it was not, still not, has not been. All I want is just the facts. Tell me what happened, tell the truth, and come across, and then I'm with you. But if you don't, if you hedge, I'm not.
Well, I guess I thought I was telling the truth. We had an instrument failure that caused the heater to trip. Subsequently to that, when the operator went to restart the heater, he did not use his training, he did not use his procedure, and he made some mistakes, and it caused the heater to be in a oxygen deficient mode that caused the heater or the fuel gas inside the heater to detonate or to explode, and caused the heater to basically split open.
He had an instrument failure. That's what you said, which caused it.
Well, the initiating cause was the instrument failure. That's what caused the heater to trip. And then it was after the heater tripped due to that instrument failure that the operator went to restart the heater, and rather than use his procedure, he tried to wing it and made some mistakes that caused it to be in a situation where the heater was where it failed.
What's the failure rate of the instrument?
I don't know that answer. These typically don't fail.
Every 4 years you do a
Test. We do a test.
and just did it in November, later last year.
When we did the test, the meter was functioning properly, and that was in November 3rd.
I believe.
Yeah, November 5th. Excuse me.
That instrument failure was catastrophic. And what do you know about that instrument? I mean, come on, somebody's got to know something about why that instrument?
Well, so the instrument failed because the sensing line that goes to the instrument was no longer reading the pressure in the pipe. And when the sensor couldn't read the pressure, then it basically drove the signal to low, which caused the heater to trip.
So we had a lot of failures occurring almost simultaneously.
Well, it was just one failure of that instrument. You know, the sensing line.
And it triggered, one triggered another.
Yep.
All right.
But what I can tell you is that
Hold
Okay.
on, Dennis. I think we've got other questions from other board
Okay,
members.
I'm sorry.
No, let him tell me. Don't cut him off.
Okay, go
Well, I
ahead.
was going to say we have restarted this heater hundreds of times without this happening because we do have a procedure. We do know how to do that. We do train the operators on how you restart a heater. For whatever reason, on this situation, the operator did not use the procedure and actually made a series of wrong moves that led to this unfortunate event.
Thank you.
Okay, Mr. Balagopalan had a question and then Ms. Verdugo-Peralta.
Yeah, it's more of a statement than anything else. I know we're not debating the issue of breakdown, and that's for enforcement to deal with for this particular case. But I did look up what the definition of breakdown is. I just like to read it. It's in Rule 102, and breakdown means a condition caused by an accidental fire or non-preventable mechanical or electrical failure. So, I'll leave it at that, and it's up to the district enforcement what they want to do with that. So, I have no further questions. So.
Okay, and as you stated, that's not one of the findings we need to make today, but
Right.
good for it to be clear on the record. But Ms.
Right.
Verdugo-Peralta, you have a question? Wait a minute. Wait, you're muted. Can you unmute yourself?
Thank you, Madam Chair. So I guess my question is, and from what you just said, I don't know that it's going to be relevant, but were there any emissions escape from the time that the heater broke down until you removed the SIMs?
No.
Okay.
No, I mean, we would have taken the fuel gas out instantly after the explosion. And so there would have been no more combustion and no emissions.
Thank you.
Okay, any other questions for Mr. Kurt, board members? Okay, I see none. Is there any other questions that board members have before we close the record? Or since we did open up the hearing, I should ask Mr. Weiss or Ms. Roberts if there are any other witnesses you wish at this time to present to give any more information to the board. Oh,
I have no further witnesses at this time.
Senator, did you have a question for Mr. Kurt?
Yes. Obviously, my question will follow. This was considered a catastrophic failure in as much as, and you can answer the question, to protect your employees and the community, you took the stack down. Why you moved to that post haste?
I'm sorry, what was, can you repeat the question?
Did you consider this to be a catastrophic failure?
Yes.
And if so, is that the reason why you took the stack down and to protect your employees, you say, the equipment and the community?
That's right. We felt that the stack was in a precarious position. It wasn't being supported by the structure that was designed to support it. If it were to fall down, that's a considerable amount of weight that could have fallen down on other process equipment. And we felt that it was unsafe to leave it in that condition. And so we were applying for permits to take it down, and we needed to get the fire department to weigh in to verify that we were thinking about it correctly.
You applied for a permit to take it down?
Yes.
The AQMD district?
Yes, we did.
And was it granted post haste right away?
It was granted with concurrence from the fire department that it was inappropriate for them to give us that permit to take it down.
what's the likely occurrence that it would have harmed the neighborhood or the neighbors? Was that-
I don't know. But
that's-
it certainly would have, a large weight falling on the ground could have been dangerous to people in the vicinity.
I just want to remind the senator that there's an exhibit that includes the email from the fire department from the interim hearing requesting that the stack be removed for public safety purposes.
Yes, can you remind us, what, do you know the number? I'll look it up too.
I recall.
Okay,
That was on Mr. Hutchins' declaration.
I recall.
okay, so it was part of exhibit number 2. Okay, thank you. Any other questions for Mr. Kern? Okay, and I know Mr. Weiss said no additional witnesses. Ms. Roberts, did you wish to call any witnesses?
Not at this time, if the hearing board has no further questions.
I'm seeing no further questions. What I'd like to do though is first, I'd like to take a 15-minute break and then we'll come back. I'll make sure there's no member of the public that wishes to be heard. We'll take closing statements and then we will deliberate. Okay, so it is now about 10:35. So at 10:50, at 10 of the hour, we'll reconvene. And for those of you who have not been on our Zooms, please do not leave the Zoom. Definitely remember to mute your microphone. I'll try to do it for you if you haven't. And if you'd like to turn off your video, you may do so too. And we will reconvene on the record at 10:50. We're off the record. It's 10 of, and I'm looking to reassemble whenever one has returned. See, Miss Verdugo Peralta is back. Not, we will wait. Great. Okay, when we left and went off the record, we're back on the record, and we were going to see if there were any members of the public present. I know I asked this earlier, but we ended up taking the matter off consent, having a hearing, and if there's anyone who is on the line from the public and wishes to be heard, you could either turn your camera on or unmute your microphone and just let us know you wish to be heard at this time. Okay, I'm not seeing anyone. And so I'm going to go to Mr. Weiss for any closing statements you wish to make. Oh, you are muted. There we go. Oh, I can't unmute you. I think you have to unmute. There you go.
Sorry, thank you. And it was such a perfect opening. So as you just mentioned, we started out on consent. But we also recognize that the board had inquiries that they wanted to make. And so we've provided not only the additional testimony in the second declaration by Mr. Rosu, but also in the form of a live witness and Dennis Kurt. I think it's pretty clear at this point that the testimony has established that the precipitating cause was a malfunction of a flow meter, but showing that product was not moving through the tubes in the heater, that indication, were it accurate, could have led to an even worse event than what already has occurred. Therefore, the heater tripped off, as it's designed to do. And in the resulting startup, that's when additional issues were created and the restart procedures weren't followed. That's the evidence that you've heard. The root cause in that case was the flow meter failure followed by failed restart procedures. We in the district council believe that prior to Mr. Kurt's testimony, that there was sufficient evidence for the hearing board to make the 6 findings required on the health and safety code. I focus on the health and safety code because, again, we are outside of the requirements of good cause. That's why I went through the process of actually bringing up the health and safety code so that everybody could see it and make sure that what we were doing was focusing on the right question. So in response to the hearing board emails, we provided Mr. Kurt. We understand that the hearing board was concerned about the evidence concerning whether there were conditions beyond petitioner's reasonable control, and that requiring compliance would result in harm to the petitioner. I mean, obviously the beyond reasonable control wording has, I think, created some confusion, certainly within myself, but I think also among board members. But when you get to the regular variance, the beyond reasonable control finding is that due to conditions beyond the reasonable control of petitioner, again, the magic words, requiring compliance would result in harm to the petitioner. I think we have demonstrated that with the evidence that has been submitted, the declaration of Mr. Rosu, the finding that in fact, based on the order of the fire department, based on the unsafe condition of the stack, the stack having to be removed and demolished, we are in fact in a position of not being able to comply at this point. There is no air quality harm that is being generated by this. The heater is shut off. The exhibits that were provided in Mr. Rosu's second declaration actually show gaps in the fuel lines. The district has verified that those gaps exist. No fuel can go to the heater, unless and until those gaps are removed and the lines are fixed and the stack is replaced and the SEMS is replaced and the supporting infrastructure for the SEMS is put in place. One of the other sections that I looked at was in the Health and Safety Code section 42352.5. And I just want to quickly call the board's attention to that, because what that says is that one of the things that the board ought to be looking at to determine whether noncompliance is beyond the petitioner's reasonable control is to focus on what the petitioner actions have been since the event took place. I think the petitioner has acted extremely responsibly. Heater was shut down. No emissions were created. The stack had to be removed to prevent further damage. As you heard in the testimony from Mr. Kurt, had the stack fallen, it could well have fallen on other process equipment. It could well have fallen on other lines that were carrying hydrocarbons. It was really important to get that stack removed. Once the stack is removed, the SEMS cannot be operational, and that's what occurred here. So I think if you look through the 6 findings that are required for the regular variance, the AOC, that you can easily meet at this point all 6 findings. I think you could have done that without having to open up the hearing based on the testimony and the evidence that was presented in the declarations and the information provided at the interim variance hearing. That said, it was clear that the board wanted to hear a little bit more. We went the extra length to provide some information to the extent we could at this point about the investigation of the incident. I don't know what else we could do. The point that I would make at this point is that we are between a rock and a hard place. If the board makes a decision not to grant the variance, the district has made it clear that there is a violation, and they may issue a notice of violation. There's no reason for that at this point. We spent a lot of time, energy, and effort with the diligence and the grace of the board to have the hearings, but it's just basically inconceivable to me at this point that the board would not grant the regular variance, because we do meet the findings, and because at this point petitioner has no option to be in compliance. That's just a fact. We have no option to be in compliance. A lot of the variance rules and procedures kind of go to whether a facility can continue to operate and create emissions. And then it's I think a tougher call for the board to determine whether to grant a variance or not. That's not the situation here. The situation here is that the heater shut down. There are no emissions. We are simply asking for the board to grant the regular variance because the 6 findings can be met. With that, I will end my closing.
Thank you. Ms. Roberts, your closing.
Thank you. I just want to bring to the board's attention, there's been a lot of talk today and at the interim hearing as to the underlying cause of this from the heater overpressure event. But I do want to bring to the board's attention, we've talked a lot about the variance findings, but those findings today are made in relevance to the SEMS and not the heater itself. I think that is an important distinction for the board to recognize today, that all of the permit conditions and all of the rules and provisions that are requested in the variance relate entirely to the operation of the SEMS and do not relate directly to the heater itself. And so the district's non-opposition, which was stipulated to and which the district does stand by at this time, non-opposition to the grant of the variance, is premised on whether or not there is evidence that could reasonably be weighed and balanced by the board to reach each of these findings with respect to the SEMS. The district does not take a position as to how, of course, the board should weigh the evidence or balance the factors. That is the providence of the board. However, with respect to the testimony today, I think it's important for the board to consider in weighing that testimony that, one, as Mr. Kurt himself characterized it, this investigation is still, these conclusions are preliminary. They have not been reviewed by the district. The district has not heard any of these conclusions and been able to evaluate them or weigh in as to come to a conclusion. So this is, at this point, sort of one-sided as to what the ultimate conclusion is. And that does speak to what weight you should give to that testimony this morning. Furthermore, the district would like to clarify that the district has not reached any conclusion as to whether rules have been violated as a result of the overpressure event itself. And because I believe a couple of board members had questions about this, I think it bears noting that that conclusion extends to whether or not the facility should or was required to call in a breakdown. As I believe board member Balagopalan emphasized the definition of breakdown, I would also point that for consideration by the board, this facilities permit, as every facilities permit, does include a condition that requires all permitted equipment to be maintained in good working order at all times. The district has not reached a conclusion as to whether there was a violation resulting from the breakdown of the heater itself. But again, because this variance is about the SEMS connected to the heater, that is not necessary for the district to weigh in a conclusion until all of that evidence is received. And because the variance today is limited to the SEMS, we believe that there is evidence between the submitted declarations and the testimony from the prior hearing, as well as this morning's hearing, for the board to adequately weigh and assess each of those findings. Thank you.
Thank you. Board members, I'll start. I do believe that even though we had a hard time at the interim hearing finding good cause, that today we can make the findings for a variance, and I'll also talk about the AOC. We could do that together since the findings and decision that have been proposed include both. So unlike normal where we would bifurcate those motions, we can do it together. But I just want to reiterate what's been said by both parties in their closing and throughout the hearing. As we know, we are here today for the SEMS, not for the heater. And so while I do believe that when we look at our second finding, conditions beyond the reasonable control of petitioner, that portion and understanding requiring compliance is part of that. I do believe that even though we're talking about the SEMS, the overpressure event and the circumstances surrounding that are relevant. However, they do take a little bit less relevance, and I do believe we have received enough evidence to make the finding with regard to the SEMS today. First of all, we did hear in the last hearing that there had been a turnaround 6 months prior to the event in November 2019. We heard today that the actual Flowmeter, which did not work and had, and that was the triggering event for the heater overpressure event, or the initial, I should say, event, that in fact was part of the turnaround, and that was found to be in good working order. So we do know that we have evidence of that. So it wasn't as though the heater were not maintained properly or in good function. That was understood to be in good function. Don't know what happened, but we don't have a final determination on that. It does seem there was some operator error, but I want to remind everyone, again, we're talking about the heater itself as the initial reason why the SEMS had to be taken down. But we did hear a lot of testimony last time about the extensive training. And we did hear today, even though it's preliminary and it's not final and no one else has weighed in, that even though there was apparently some error on the operator's restart up, which caused the event itself, of the overpressure event itself, that they weren't following proper procedures, and even though they had been trained on those procedures. So I think that also is evidence that supports a finding of beyond reasonable control. And finally, I do want to just point in, and I'm only talking about beyond reasonable control because I think everything else can be easily found because there are no excess emissions since the heater is shut down. And blinds and air gaps have been installed. But finally, there, as a result of that overpressure event, we've heard sufficient evidence that that stack had to come down. And in particular, that the fire department required it for safety. And I know, Senator, you asked some questions. Could there have been significant issues that could have occurred if anything had happened with that stack? No one can know for sure, but clearly it was not safe and had to be removed. And as a result, the SEMS there's no place for the SEMS to go, even though it had continued operating after the heater shut down, which I want to point out. I think that also goes in favor of beyond reasonable control, because if that stack didn't have to come down, it wasn't an ignition source, that was another issue, or that the stack was not stable, that they would have continued to have the SEMS operating, because they did at first. So for those reasons, I think I can find the beyond reasonable control. And finally, just to put in the issue that I think Mr. Weiss was trying to raise at the very beginning, and the reason why he opened up this hearing, and the issue that is in hearing board exhibit one response from Ms. Roberts, is just to remind us of what I read into the record, that beyond reasonable control finding is a bit of a lesser standard. It's a much more stringent standard when we're looking at good cause to hold a hearing in absence of notice to the public, when it comes to the issue of could it have been reasonably avoided by petitioner, but that's a stronger standard. And so just because we couldn't find it then doesn't mean we can't find beyond reasonable cause now, or beyond reasonable control, sorry, now. Anyone else have thoughts on any of the findings, but in particular, I suppose the one that's really was an issue today, which is beyond reasonable control? Anyone else have any thoughts? Okay. Oh, Mr. Balagopalan, go ahead.
Yes, I think I agree with you, but the difficulty I always have with this type of cases is trying to make sense of doing SEMS when the source is not operating. The source is down. Clearly, we know why the stack is down and the SEMS cannot operate. If we really need to have SEM data, then we should require a portable SEM in there and measure basically ambient air, which is not what we want to do, because that will create its own problem. So that's the problem I always had with this type of cases. And I will again bring up, the rules have been proposed rules to 18.3 and 4 have been amended for the landing rules for reclaim and to address SEM. So hopefully language will put in which will be very clear. Just like I pointed out before, there's an 1110.2 for engines. If the source is not operating, you don't have to calibrate or operate the SEMS, so that's very clear. I think the reclaim rule, the assumption is no matter what, even if the source is not operating, the SEMS has to operate, which is, in my mind, it's maybe using the petitioner's word, nonsensical, but that's the difficulty I have, but I agree. I think the conditions are very good. And we look at Exhibit 4 and I think it's Exhibit 4 in the picture in Exhibit 4 and it's Exhibit B, listed, tagged as Exhibit B. You'll see very clearly there it's tagged out. You see the locks there. So those are the tag out procedures that the refiners do, make sure that accidentally somebody doesn't turn the gas on and cause another problem. So they have, I'm sure they have extensive tag out, tag in, lockout procedures, and you can see these things are tagged out and the blinds are put in there and it's removed from service and they'll follow procedure before it brought. So clearly nothing is going to operate until the heater is repaired, and then before they operate the SEMS and the stack is back up and the SEMS is operational before they start the heater out. And I think the condition reflect that. The difficulty I always have, and it should be a slam dunk kind of thing, but I always have difficulty is, why we, the idea when there's this, it's a non-source. It's really a, if this is a show about nothing, it'll be a Seinfeld show, because it's really emission. There's no emissions. Because everything is down. There's no, like I said, no source. There's no emissions to monitor, even if they could, and the only option is to bring a rental, which we, and to monitor ambient air, or basically air in the refinery, which could be, could have some things, but that's not what we want to do. So that's the difficulty I have. So I'm going to And it's only for that reason I'm going to vote no, just to make a point, not because I don't think they have a good case, here, but I just have difficulty making that one finding that they're in violation. I find it very hard to believe, and well, maybe the district has done it. Go give a violation because the source is not operating anything.
Let me ask you, Mr. Balagopalan, are you saying that you cannot read that rule to require it, or that it should not require it? Because that's a very different point.
Oh, I don't know. When I read it, it says continuous. I'm reading it probably in a different way, and that's not the district interpretation, and that's fine. I can go with that. But I do. It says continually measure. Then there's nothing to measure because the source it's not in operation. There's no there's no source of emission.
It
There's
doesn't,
nothing.
but it doesn't say continually measure unless there's nothing to measure. It just continually measure, correct? So that's the only
Continually
way.
measure
No.
NOx. It says continually measure NOx, CO, and the other variables like flow rate and so forth. But there's nothing to measure, so you can't do it. So it's just counterintuitive is what I'm saying, because
Well,
and
let
the
me
rule is
stop
not.
you. Let me stop it, because I really do want to understand. If you are reading it to require it, then it's a violation, and you can make the finding.
No, it's the opposite. I don't read it explicitly that it's required. At the same time, I think the rule doesn't explicitly say it's not required.
You think it's
When I
not?
read it, I don't think it's required because there's no emissions to monitor, basically. And then 96 hours and limitation is if the SEMS had to be repaired, and that is if the source was operating. And if this was an issue of the SEMS been out because the source is operating, and then they had some reasons they had to repair for an extended period of time, the SEMS, I can see that because there is a source of emissions, NOx, that has not been captured by the SEMS. We're talking about the SEMS essentially. If the SEMS cannot, and I think we've gone through this, and it cannot operate because the stack had to be taken down. So there's nothing to record. So, and I think that's where that rule language, maybe in my mind, it's hopefully will get clarified in the amendments to the rule. So it's very explicit, in saying yes or no, what do you have to do in this situation when a source is not operating, not when the SEMS is not operating, but when the source of the emission is down,
Okay.
which does not enable the SEMS to operate.
Thank you. And so just to summarize, Mr. Balagopalan is saying that he cannot make finding number one, that there is a violation. I just want to point out, just in response, number one, I think when you're presented with a rule that says you must continue to monitor, you must continue to do so unless there's a clear exemption. And there's reasons for that. You can see that one of the requirements of, or the conditions of the proposed variance that we're considering today is to install blinds and air gaps and make sure that there is no flow of anything into the heater. And so, but that wouldn't be required if the rule just said, okay, just, if your heater's not on, just don't worry about it. You don't have to operate your SEMS. Well, how could the district know for sure that that heater's not operating? So I think it's intentionally vague. However, that doesn't matter. I guess the point is that I can read it to require it. And I think even the more important point that Mr. Weiss made in his closing is it leaves petitioners and facilities between a rock and a hard place, because the district has made very clear that the district reads that rule to require monitoring and that an NOV would issue. So I just want other board members, when deciding whether you can make the findings, to keep that in mind, that regardless of whether one of us believes that there's gray area, the district does not. And so I think that really lends credence to making that finding.
Yeah, and don't get me wrong, I think the conditions are very good. I think I've said before too, this could have been handled as an enforcement discretion, and those conditions are still, conditions that the source would take anyway, but you can ensure as part of the what do you call it, enforcement discretion, but that we are not there or here, it's, so it's come before the board for a finding. And so I have different, if really that was so critical that the SEMS be up, then bring a rental unit, then we should require a rental to be brought on site and to have that running.
I think that I would be able to make the findings even without that, because the rental wouldn't make any sense from a cost versus benefit perspective.
Exactly, yeah, right.
It's not reasonable.
Okay, that's,
Thank you for your thoughts. Board members, Ms. Verdugo Peralta, do you want to unmute yourself? There you go.
Thank you, Madam Chair. Based on the beyond reasonable control, for that reason, I can make findings. I'm basing it mostly on that. I still have concerns about that root cause analysis report and how the findings from OSHA and the fire department are going to be able to give the district the ability to have a summation of facts. I don't know whether they have to come back to us and give us a report on that. I certainly would like to see something like that. But going back to what I am supposed to be looking at to make the findings, I can, as I said before, based on the reasonable control. Thank you.
Thank you. Anyone else wish to add to the discussion on the findings for a regular variance? Okay. Let me just add to the discussion with regard to the alternative operating conditions, that I also believe that the additional findings that need to be made for that have also been made. And mostly that just has to do with the fact that there are no excess emissions. And most of the additional findings have to do with that. There is no breakdown in terms of the SEMS itself. So that's not an issue. And so all the findings as are laid out in the proposed findings, I can make those findings for the AOC as well. Any thoughts on that before we move on? Okay. All right. Well, board members, then I will make a motion, and my motion is going to be, well, let me make it and I'll clear. In the matter of Tesoro Refining and Marketing Company, LLC, case number 4982-124, I move that we grant the proposed findings and decision in order, granting a regular variance and alternative operating conditions as is found in Exhibit 5, based on the findings that we've discussed and that are laid out in Exhibit 5. And it will be for the equipment and from the rules as are laid out in Exhibit 5. And in particular, they are the requirement to have the SEMS continually monitoring, despite the fact that the SEMS can no longer be there because the stack has been taken down and the heater is no longer working. And it will be for the period of time that is defined in proposed order paragraph A, with regard to commencing now and going for a period not exceeding 6 months or until notice is provided as specified in condition 9, whichever comes first, commencing from the date of this order. And I further move that we adopt all of the conditions and alternative operating conditions as are proposed and laid out with no changes. And just to be clear for the record and for the public, that includes, as we've been talking about, maintaining an air gap and blind flange on the main and pilot refinery fuel gas lines to the heater for the entire variance and AOC period, which ensures that the heater will not be used while the SEMS is not in operation. I also want to be clear that we will need to change and modify, even though it has been stipulated, but the only changes we need to make are technically to note that the parties did appear, in fact, and also to include, which I will assist the clerk with, just some additional paragraphs defining some of the information we received today on the preliminary results of the root cause analysis that was conducted. And otherwise, they will stay as they are, and there are no excess emissions. Is there a second?
Second.
Motion.
Dr. Bernstein has seconded the motion. Is there a discussion, further discussion on that motion? Mr.
Only just for
Balago.
clarification, the AOC will expire 2 months prior to the regular variance, right? Because it says that in the proposed order, the AOC will be effective commencing March 10. And that's on condition 10 also, the date the petition for the variance is filed. So it looks
Yes,
like,
sorry, thank you for pointing that out. That is a particular rule of AOCs that the, while regular variances cannot be retroactively applied, AOCs can be. And so shall become effective. Okay, so 2 months before. No, that, wait, A says,
because we're giving for 6 months from this date.
6 months from this date. So it won't end sooner.
Yeah, but the AOC will end sooner because the AOC is going back 2 months.
But it's not saying for a period of 6 months, it's saying a period not exceeding in total 6 months. Let me just
Yeah.
read that more carefully. Well, right, yeah, okay. No, it does say for a period not exceeding 6 months of commencing from the date of this order. So it's the same 6 months, Mr. Balagopalan. The way I read it is that the regular variance in AOC is granted for a period not exceeding 6 months, and then or until notice is provided, whichever comes first, commencing from the date of this order, which would be today.
Okay.
Even though it retroactively reaches back the 2 months for the AOC, the date of the order is today.
Okay.
And that's in our rules, effective dates of orders on the day when they are, when a majority of the board votes. Okay, but thank you for that. I'm glad we cleared that up. I didn't catch that potential discrepancy. Is there any other discussion on the motion? Okay, Senator, how do you vote? Oh, sorry.
No,
Senator, how do you vote?
no,
No. Dr. Bernstein, how do you vote?
Aye.
Mr. Balagopalan, how do you vote?
Would no.
Ms. Verdugo Peralta, you vote?
Aye.
I vote yes. Motion passes 3-2. And I just wanted to be very clear, and good luck with that, that the beyond reasonable control finding was made based on the SEMS, and that we were looking at it differently for the SEMS than we would if it were the heater that were coming back online. Based on the evidence that we received today and at our previous hearing on the interim. And of course, it's always subject to change, but that's based on the state of the evidence today. Okay, thank you all, and thank you to the parties for appearing and having your witnesses available for the board. We appreciate it. Board members, any other business before we adjourn for today? Okay, hearing none, we are adjourned, and we will be back on for tomorrow at 9 o'clock.
Thank you, Madam Chair. Everybody stay safe.
Thank you, all of you as well.
Thank you.
Bye.
Thanks, everybody. Take care.